The Drug Enforcement Administration does not dispatch 12 personnel to a county murder trial as a courtesy. Under 21 U.S.C. Section 878, DEA agents carry federal authority to investigate narcotics trafficking, related financial crimes, and the criminal networks that sustain them. Their statutory mandate does not include domestic homicide. It does not include spousal death investigations in rural Ohio. And yet, entries 39 through 55 on the state of Ohio's official witness list in Case number 2, 6 CR 88 list, 12 agents and task force officers from the DEA's Dayton Field Office as witnesses the prosecution intends to call at trial. Before this document explains a single piece of physical evidence, before it names a single forensic scientist, before it identifies the FBI laboratory analysts flying in from Quantico, the DEA is already on the page. That is the question this document forces. Not what happened to Ashley Flynn. You already have that answer. The question is what the Drug Enforcement Administration found underneath it. On April 8th, 2026, pursuant to Ohio Criminal Rule 16b, 1e, prosecuting attorney Paul M. Watkins filed the state of Ohio's witness list in the Common Pleas Court of Miami County. Case number 26, CR 88. Presiding Judge Janine N. Pratt. Criminal Rule 16 governs discovery obligations in Ohio criminal proceedings. Under subsection B1E, the prosecution is required to provide the defendant with a written list of the names and addresses of all witnesses it intends to call at trial. The rule exists to prevent trial by ambush, to ensure the defense has adequate opportunity to investigate and prepare a responsive strategy for each witness the state intends to present. The document Watkins filed runs to 9 pages, 172 numbered entries, delivered electronically to defense attorney Emily Smith on the date of filing. Reading a Criminal Rule 16 witness list as a forensic document rather than a procedural formality reveals the architecture of a prosecution's evidentiary strategy before a single witness takes the stand. The categories of institutions subpoenaed, the federal agencies represented, the number of law enforcement personnel called, the specific financial and digital records sought. Each of these is a data point indicating what the prosecution believes it can prove and through what mechanism it intends to prove it. This document is that architecture. 9 pages, 172 data points, the law enforcement inventory entries 1 through 21, Tip City Police Department, 260 South Garber Drive, Tip City, Ohio. Chief Greg Adkins leads the list, followed by Captain Tony Smith, Detective Sergeant Mike Morgan, Detective Adam Bernard, Detective Brad Klein, Sergeant Chris Graham, Sergeant Corey Ryamiller, Sergeant Craig Nye Jr., Sergeant Darren Sotar, through pilots, patrol officers, and Special Agent Adam Grubb. 21 personnel from a single municipal department. That number represents comprehensive departmental coverage, every rank, every unit, indicating the prosecution intends to establish chain of custody, scene documentation, investigative procedure, and response chronology through multiple independent officer witnesses, rather than consolidating testimony. The practical implication: any defense challenge to investigative procedure at the Tip City level will face 21 separate accounts of what occurred. That is not an accident of disclosure. That is insulation. Miami County Sheriff's Office adds 13 more entries. Troy Police Department contributes several further witnesses. By entry 38, before a single non-law enforcement witness appears, the prosecution has assembled a law enforcement block of approximately 40 officers across 3 separate agencies. Each agency conducted independent components of this investigation. Each component requires independent witness authentication. 7747 Clio Road, Dayton, Ohio 45459. That address is the Dayton Resident Office of the Drug Enforcement Administration, a field operation under the DEA's Detroit Field Division covering southwestern Ohio. It is not a headquarters. It is an operational office, the kind staffed by agents who run active investigations, execute warrants, and build prosecutable cases. Entry 39, S.A. Sarah Dearman. Entry 40, S.A. Andrea Kinzig. Entry 41, S.A. Kenneth Howard. Entry 42, T.F.O. Fred Zolas. Entry 43, T.F.O. Zachary Farkas. Entry 44, S.A. Michael Torn. Entry 45, T.F.O. Cameron Yauger. Entry 46, T.F.O. Jacob Rillo. Entry 47, S.A. Seth Webb. Entry 48, S.A. Nicholas Graziosi. Entry 49, S.A. Jordan Flexman. Entry 50, S.A. Deanna Williams. S.A. designates Special Agent, a federally credentialed DEA officer. T.F.O. designates Task Force Officer, typically a local or state law enforcement officer embedded within the DEA task force under a joint operations agreement, carrying federal authority for the duration of their assignment. 12 witnesses, 8 special agents, 4 task force officers, 1 address. What DEA presence means legally. The DEA's investigative jurisdiction derives from the Controlled Substances Act, codified at 21 U.S.C. Section 801 ETCQ. Their operational authority under 21 U.S.C. Section 878 includes the power to execute warrants, make arrests, carry firearms, and seize assets in connection with controlled substance violations and related offenses. A domestic homicide prosecution in an Ohio county court does not trigger DEA jurisdiction on its own. The murder of Ashley Flynn at 212 East Franklin Street in Troy, Ohio, is a state crime prosecuted under Ohio Revised Code Section 2903.02. The DEA has no mandatory role in that prosecution. They are present because they chose to be. And they were permitted to remain because what they were investigating intersected with the state's homicide case in a way that prosecuting attorney Paul Watkins determined was admissible, relevant, and significant enough to present to a jury. 12 witnesses is not a support role. 12 witnesses, each with independent observations, each capable of presenting a discrete evidentiary segment, that is, a substantive prosecutorial component. The DEA is not attending this trial. The DEA is testifying at it. Financial crimes and the DEA intersection. The most probable area of DEA involvement in a case of this nature is asset tracing and money movement analysis. Under 18 U.S.C. Section 1956 and Section 1957, federal money laundering statutes cover financial transactions involving proceeds from specified unlawful activity. If those transactions involved controlled substances at any level, the DEA carries concurrent jurisdiction alongside FBI financial crimes units. Cross-referencing this against the 8 financial institutions subpoenaed later in this same witness list: Wells Fargo, Ally Bank, Citibank, Fifth Third Bank, Foresters Financial, PayPal, JP Morgan Chase, and Banner Life Insurance. The prosecution appears to be presenting financial evidence through 2 parallel tracks: corporate record keepers authenticating account data and DEA agents providing investigative context for what that data means. The 2 tracks are designed to be mutually reinforcing. The bank produces the record. The federal agent explains the pattern. FBI Laboratory, Quantico entries 58, 59, and 60. Dr. Diana Wright, Sarah Stuchel, Brittany Swisher. 2501 Investigation Parkway, Quantico, Virginia 2, 2135. The FBI Laboratory operates under 28 CFR Section 0.85, which authorizes the FBI to conduct forensic examinations in support of law enforcement agencies at the federal, state, and local levels. Access to FBI laboratory services for state prosecutions is not automatic. It requires a formal request, evaluation of the case's requirements, and allocation of laboratory resources based on the nature of the forensic question being addressed. 3 analysts from that facility are listed as prosecution witnesses in a Miami County, Ohio homicide trial. The FBI laboratory maintains specialized units that state-level forensic labs cannot replicate. The DNA analysis unit operates under FBI quality assurance standards and applies methodologies governed by SWG-DAM guidelines. The Digital Evidence Laboratory handles extractions from devices with advanced encryption or damage states. The Trace Evidence Unit performs materials analysis at a level of precision requiring instrumentation not available to most state BCI facilities. 3 analysts, 3 possible specialties. The prosecution has not disclosed at this stage what those analysts examined or what their findings produced. What the witness list establishes is that the prosecution considers their testimony essential enough to bring federal witnesses from Virginia to Ohio, with all the procedural and logistical complexity that entails. Under Ohio Rule of Evidence 702, expert witnesses must be qualified by knowledge, skill, experience, training, or education, and their testimony must assist the trier of fact in understanding the evidence. FBI laboratory analysts routinely meet and exceed that threshold. Their institutional credentialing, peer-reviewed methodologies, and accreditation under ASCLD standards make their testimony exceptionally difficult to challenge on qualification grounds alone. The prosecution chose the hardest to impeach analysts available. That is not incidental. Ohio Bureau of Criminal Investigation. Entries 72 through 85 draw from the Ohio Bureau of Criminal Investigation, the state's primary forensic laboratory and investigative support agency operating under Ohio Revised Code Section 109.51 ATCQ. Dr. Brian Casto and Alex Miller are identified as forensic scientists at BCI's Bowling Green facility. Additional personnel: S.A. David Hammond, S.R.S.A. David Wilhelm, C.S.T. Holy Reichsack, Jared Schultz, Andrea Weisenberger, Vicky Bartholomew, Joanne Gibb, Lindsay Koenig, Nicole Augerbach, Jennifer Akbar, Philip Irian, and analyst Samantha Molnar extend the BCI witness block through entry 85. 13 BCI-affiliated entries on this list suggests the prosecution is presenting forensic evidence across multiple independent categories, not a single forensic finding, but a convergence of findings, each requiring its own qualified expert. BCY's forensic divisions cover DNA analysis, serology, drug chemistry, firearms and tool marks, latent prints, digital forensics, and question documents. Each discipline is a separate specialty. Each finding requires a separate witness. The prosecution has listed the analysts rather than relying solely on certified reports, indicating it anticipates methodological challenges and is preparing to defend every forensic finding on the stand. Beginning at entry 92, the witness list transitions from human witnesses to institutional record keepers. The legal mechanism operating here is the subpoena ducis tecum, a court order compelling a third party to produce specific records for use in a legal proceeding. Under Ohio Criminal Rule 17C, A subpoena juris tecum may be issued to any person or entity, including corporations, requiring production of books, papers, documents, data, or other objects. The producing party designates a keeper of the record, a corporate custodian, to appear at trial, authenticate the produced records, and establish foundation for their admission as business records under Ohio Rule of Evidence 803-6. Once properly authenticated, those records become admissible as an exception to the hearsay rule. They speak for themselves. They require no witness memory, carry no credibility questions, and cannot be shaken on cross-examination the way a human witness can. The prosecution has built a subpoena structure spanning 5 cellular carriers, 8 financial institutions, and 14 technology and platform companies. Each keeper of the record entry represents a discrete category of authenticated documentary evidence the jury will receive. 5 carriers. The device question: Boost Mobile, Dish Wireless LLC, Englewood, Colorado. Entry 92, Verizon, Bedminster, New Jersey. Entries 93 and 94. 2 separate entries at different addresses, indicating either 2 separate subpoenas or 2 separate record divisions within the carrier. T-Mobile, Parsippany, New Jersey. Entry 108, AT and T-Mobility, North Palm Beach, Florida. Entry 109, Charter Communications, St. Louis, Missouri. Entry 110, 5 carriers. Collectively, those 5 represent total coverage of the United States cellular market. Every major network is present. Under the Stored Communications Act, 18 U.S.C. Sections 2701 through 2713, law enforcement may obtain the contents of stored electronic communications through a search warrant supported by probable cause. Call detail records, including numbers dialed, duration, cell tower location data, and device identifiers, may be obtained through a less restrictive court order under 18 U.S.C. Section 2703D. 5 carriers subpoenaed means the investigation did not assume a single device on a single account. It accounted for the possibility, or the confirmed knowledge, of multiple devices, multiple SIM cards, multiple numbers. That level of carrier coverage is applied when investigators have reason to believe communications were distributed across platforms and devices rather than consolidated on one. Financial institutions, the motive documentation, Wells Fargo Bank, Ally Bank, Citibank, Fifth Third Bank, Foresters, Financial, PayPal Holdings, including Venmo and Zoom, JP Morgan Chase Bank, and Banner Life Insurance. 8 institutions. Every account held, and potentially every account held in common with Ashley Flynn, now opens to the prosecution. Under Ohio Evidence Rule 803-6, business records maintained in the ordinary course of business are admissible as exceptions to the hearsay rule, provided a qualified custodian testifies to the institution's record-keeping practices. Each keeper of the record entry on this list provides that foundation. The forensic significance of 8 simultaneous financial subpoenas is the cross-referential picture they produce. No single account tells a complete story. 8 accounts, covering checking, savings, investment, digital payments, and insurance, generate a comprehensive transaction map across every financial instrument in use. Banner Life Insurance carries specific evidentiary weight under Ohio case law. In homicide prosecutions involving intimate partner relationships, financial benefit from the victim's death is categorized as circumstantial evidence of motive under Ohio RC Section 2901.22 and related case authority. A life insurance policy, its existence, its value when it was established, whether the premium payment pattern changed in the period preceding the death, is admissible on the question of motive without requiring direct proof of intent. The prosecution listed Banner Life Insurance. The prosecution does not list evidence it does not intend to use. The technology subpoenas. Google produces search history, location history from Google Maps and Google Timeline, Gmail, data through a separate subpoena entry, Google Drive contents, and device data from Android systems. Apple produces iCloud backups containing message logs, call history, photographs with embedded geolocation metadata, health and activity data from Apple Watch integration, and device backup states that may recover deleted content. Meta produces Facebook activity logs and Messenger content. Instagram and WhatsApp, both Meta subsidiaries, are subpoenaed separately under their own data architectures, producing direct message content, story archives, and connection metadata. Microsoft and GroupMe cover productivity account data and group messaging content respectively. Snap Inc. presents a specific forensic consideration. Snapchat's architecture is designed around ephemeral content, but Snap retains metadata even when content is deleted, and under appropriate legal process, produces account activity logs, contact lists, and recoverable message metadata, even where content has been purged from user-facing storage. Amazon produces purchase history and Alexa device logs where applicable. Ring LLC, subpoenaed as a separate entry rather than subsumed within Amazon's broader record production, indicates the prosecution specifically identified Ring footage as a distinct evidentiary category. Ring doorbell and security camera systems upload footage continuously to cloud storage. Under Ring's law enforcement guidelines, footage is retained and producible under legal process even after user deletion within a specified window. Doorbell camera footage carries significant probative value in timeline reconstruction. It documents arrivals and departures with timestamp precision, captures vehicle movements, and records audio in proximity to entry points. It cannot be retroactively altered by the subject. Someone's camera recorded something. The prosecution knows what it recorded. The jury will see it. Entry 120. Ford Motor Company, keeper of the record. 1 American Road, Dearborn, Michigan, 48126. Modern Ford vehicles include a combination of systems that generate continuous operational data. The primary categories relevant to a criminal investigation are as follows. The Event Data Recorder, EDR, mandated under 49 CFR Section 563 for vehicles manufactured after 2012, captures vehicle speed, engine throttle, brake application, seatbelt status, and airbag deployment in the seconds preceding a defined trigger event. EDR data is preserved in non-volatile memory. Separate from the EDR, Ford's Sync infotainment system logs GPS navigation history, Bluetooth device pairing records identifying connected phones and the times of connection, call logs from paired devices, audio source selection, and user-initiated destination searches. This data is stored in the vehicle's internal memory systems and is recoverable through forensic extraction tools, including the Burler Corporation's IVE platform, which is specifically designed for vehicle infotainment system forensic analysis. Ford's FordPass telematics service adds a third data layer, transmitting real-time vehicle location, speed, fuel level, and system diagnostics to Ford's servers. That server-side data is what the keeper of the record subpoena captures. Not just what is recoverable from the physical vehicle, but what Ford's own infrastructure retained remotely. The legal framework is clear. Under Carpenter versus United States, 138 SCT 2206, 2018, law enforcement access to historical location data held by third parties requires a warrant supported by probable cause. That warrant was obtained. Ford Motor Company is on the witness list because the prosecution has the data and intends to present it. Every location that vehicle visited, every timestamp on every movement, every door event logged during the period the prosecution considers material, every navigation destination entered, every phone connected to the system, and when? The vehicle could not lie. It was never asked to. It simply recorded. Entry 125. Christian Life Center, keeper of the record. 3489 Little York Road, Dayton, Ohio 45414. Entries 126 through 137. Jordan Hansen, Enos Marshall, Leon Blaylock, Josh Bonzelaire, Elizabeth Martin, Chris Pinkston, Paige Pinkston, Savannah Leach, Mia Hernandez, Grace Marshall, Tanya Metcalf, Douglas Carpenter, all at the same address. 13 entries, 1 institution, and 12 of its members. The evidentiary framework governing faith community records in Ohio criminal proceedings does not provide blanket protection. Ohio Revised Code Section 2317.02c establishes clergy penitent privilege, protecting communications made to a member of the clergy in their professional capacity as a spiritual advisor when the communication is made in confidence. That privilege belongs to the communicant, not to the institution, and not to third parties who may have observed or heard. Critically, Section 2, 1317.02c does not protect third-party observations. It does not protect communications made in group settings where confidentiality was not reasonably expected. It does not protect attendance records, financial transactions, event participation logs, or organizational communications. It does not protect the testimony of fellow members who witnessed behavior within the community context. The prosecution subpoenaed Christian Life Center's institutional records and listed 12 of its members as witnesses. Under the applicable privilege framework, what those 12 individuals observed, behavior, statements made in non-privileged settings, interpersonal dynamics within the community, is fully available to the prosecution. 12 witnesses from a single institution represents a concentrated evidentiary cluster. In prosecutorial strategy, clusters of this nature indicate the prosecution found a specific evidentiary scene within that community, a set of overlapping observations, each partial on its own, but collectively capable of establishing something the prosecution needs to prove. What that something is, the document does not say. What it says is that 12 people from that address are prepared to say it under oath. The public version of the state's witness list contains multiple redacted entries. Entries 65 and 66. Entries 139 through 144. 6 consecutive redactions in the block immediately preceding entry 145. And entry 172, the final entry on the entire document, entirely obscured. Redaction of witness identities in a public court filing is governed by Ohio Criminal Rule 16 and related case authority addressing witness protection. The prosecution may shield a witness's identity at the disclosure stage, where disclosure would compromise the physical safety of the witness, where the witness is a confidential informant protected under Roviaro versus United States, 353 U.S. 53, 1957, or where the witness is a cooperating individual whose agreement requires deferred disclosure. Under Roviaro, the government's privilege to withhold a confidential informant's identity must be balanced against the defendant's right to a fair trial. Where the informant's testimony is central to the prosecution's case, disclosure may ultimately be required. Where the informant's testimony provides foundational support rather than direct proof, the privilege is more likely sustained. 6 consecutive redacted entries at positions 139 through 144, located immediately before Ashley Flynn's own entry, suggest a cluster of protected witnesses whose observations are proximate to the most sensitive evidentiary territory in this case. Entry 172, the last name on a 172-person list, is covered entirely. The final witness, the prosecution considered whoever that entry represents significant enough to list and sensitive enough to simultaneously conceal. The defense has received the unredacted version under Criminal Rule 16. The public has not. That asymmetry is intentional and legally appropriate. It is also, forensically, the most significant gap in what this document reveals. There is a final witness. The public does not know who they are. The prosecution does. Entry 145, Ashley Flynn, 212 East Franklin Street, Troy, Ohio, 45373, under Ohio Evidence Rule 803-6 and the Digital Records Framework established through state and federal case law. A deceased individual's digital accounts, communications, and data records are fully producible and admissible through appropriate third-party custodians. The account holder's death does not extinguish the evidentiary value of what those accounts contain. Ashley Flynn's digital presence, her communications across the platform subpoenaed, her financial activity across the institution subpoenaed, her location data preserved in cellular tower records, her device data captured in iCloud and Google backups, her search history, her deleted content recoverable through forensic extraction, all of it remains intact in third-party infrastructure. All of it was subpoenaed. All of it is coming into evidence. Her listing at entry 145 is not symbolic. It is evidentiary. It signals that the prosecution has organized her digital record as a discrete evidentiary component, treated as a unified body of evidence attributable to her directly. What Ashley Flynn communicated, to whom she communicated it, what she searched for, what she documented, what she retained, and what she attempted to delete, what her location data shows about her movements, what her financial records indicate about her circumstances. The prosecution has all of it. She is, by designation, of the prosecuting attorney of Miami County, Ohio, a witness in her own murder trial. 144 other witnesses exist to carry that account into a courtroom. 9 pages, 172 entries filed pursuant to Ohio Criminal Rule 16b(1)(e). 12 DEA agents from the Dayton field office, 3 FBI laboratory analysts from Quantico, 13 BCI forensic scientists and support personnel, 40 law enforcement officers across 3 agencies, 5 cellular carriers, 8 financial institutions, including a life insurance company, 14 technology and platform corporations, Ford Motor Company, a faith community, and 12 of its members, 19 residents of the neighborhoods where this story unfolded, and at entry 145, the woman the entire architecture was constructed to represent. The prosecution's theory of this case will be argued at trial. The evidence supporting that theory has been disclosed through this document with the precision that Criminal Rule 16 requires and the comprehensiveness that the prosecution's preparation reflects. Caleb C. Flynn is presumed innocent under Ohio law and the 14th Amendment of the United States Constitution. That presumption will be tested before Judge Jeanine N. Pratt in the Common Pleas Court of Miami County. The state of Ohio will attempt to rebut it with 172 witnesses and the institutional record of a man's entire documented life. The exhibit files for case number 26CR88 remain open. Ashley Flynn was 33 years old.